Today we are going to talk about the right to privacy and how it has evolved and changed over the years in its recognition by the Supreme Court of India. So, obviously, the right to privacy cannot be discovered or introduced. It has been read into and recognized as a part of an integral part of Part 3 of the Constitution of India in recent times. But this was not always the case. In previous years, the Supreme Court and other courts have held that the right to privacy is not a fundamental right and is not contained in the right to personal liberty, etc., which is enshrined in the Constitution of India. So today we are going to talk about a few judgments, majorly three, four judgments, which have shaped the right to privacy law in India and have shaped the landscape, which has led to wide scale benefits to us as citizens. So, the first judgment I want to talk about, I will colloquially refer to as the search and seizure judgment, which was all the way in 1954, MP Sharma versus Satish Chandra. And in this case, there was a company known as Dalmia Jain Airways, and it was noticed that there was wide-scale fraud and embezzlement done through that company. And ultimately, various investigations were instituted against the company and also its allied concerns. And the main issue in that matter was that pursuant to applications being made before the district magistrate, uh, directions had been issued for search and seizure of the offices of Dalmia Jain Airways and other offices of allied concerns. And then these were challenged, and ultimately the petition reached the Supreme Court, and the Supreme Court said, we are going to consider whether these search and seizure provisions contained inter alia in the CRPC in section 1996 are constitutional or are dehors the constitution or ultra vires the constitution. So the challenge was mounted on primarily two grounds in this case. The challenge was mounted on firstly on Article 23, and what Article 23 provides is that no person accused of any offense shall be compelled to be a witness against himself. So, this is the right against self incrimination, which is a fundamental right as part of protection in respect of conviction of offenses, part of Part 3 of the Constitution. So, this was the first limb of the argument that these search and seizure provisions are violative of 23 of the Constitution. And the second provision was Article 19(1)(f). Now, 19(1)(f), what does it provide? 19(1)(f) says protection of certain rights regarding freedom of speech, etc. All citizens shall have the right, and then F was right to property, which was thereafter in 1951 itself removed with retrospective effect. So now it's no longer a fundamental right under 19(1)(f). But in that case, anyway, they discussed this. And what they held was, insofar as Article 19(1)(f) is concerned, search by itself is not a restriction on the right to possess and enjoy property. And seizure is only temporary because suppose some documents or some evidence is seized from, say, your office, it will ultimately be returned to you. So it's only a temporary confiscation for the purpose of carrying out an investigation. So they discarded the argument on Article 19(1)(f) at the outset itself, and they continued on the argument of Article 23, whether these provisions are violative of the right against self incrimination. And we will discuss how this becomes relevant because they also discuss in this context the right to privacy. So, the right to privacy is a two pronged concept. One is the right to privacy against the state, and the other is the right to privacy against non-state actors. In this judgment, it was a 8-judge bench. They were considering only the right to privacy insofar as it relates to self-incrimination and under Article 23. So, therefore, self incrimination is against the government and not against any non state actors. So, what do they say about Article 23? The argument was this that the Article 23, the right against self incrimination, doesn't merely refer to oral testimony. It is also it also refers to evidence of any character whatsoever. It extends not only to compelled production of documents from a person's possession, but also to compelled production of oral and documentary evidence from any other person who may be incriminated thereby as an accused in future proceedings. So they say that this has to be uh, Article 23 has to be expensively looked at, and forcible search and seizure is on the same footing as compared to compelled production of documents from a person from whom they are seized. This is the argument. This was the argument of the petitioners. And first, they referred to British and American jurisprudence on this, of which there's a considerable amount of jurisprudence. And what they concluded was the American jurisprudence and the British jurisprudence is similar to what is enshrined in 23. But in American jurisprudence, it has been held that unreasonable searches and seizures of documents fall equally within the mischief of the Fourth and Fifth Amendments as the right against oral self incrimination. So, if I'm compelled to produce some document, it's the same as me being a search and seizure being directed against me, and it amounts to self incrimination, and therefore it is and unconstitutional and protected by the Fourth and Fifth Amendment. The judges also discuss the CRPC and the earlier Evidence Act, etc. And then they say that there's considerable divergence as to whether the right against self incrimination is good or bad. Why is this? Because it's definitely a right which protects the citizens, but also at the same time, certain actors can frustrate the police, can frustrate the state, and ensure that they get away in criminal matters because of the right against self incrimination. So, this was what was discussed. And then finally, they came to a reasoning and they applied what I would say is not a very expensive understanding of Article 23. So, what they say is that to be a witness under Article 23 should not be construed narrowly, it should be construed expansively. And it is available, Article 23 is available to a person against whom a formal accusation relating to commission of offense has been leveled. So it's not available to people who have not been accused of a crime. It's only available to people who have been accused of a crime, whether or not a charge sheet has been filed, whether or not uh, there is actual prosecution of the matter. So, what they hold is any compulsory process for production of evidence of documents which may support a prosecution against them is covered by Article 23. However, they say that searches and seizures do not amount to compulsory requirement to produce any documents. It is not a process of compulsory production of evidentiary material because here the police, it's a third person who is being directed to search and seize and not you yourself. You are not producing it yourself. This is the reasoning they hold. It is therefore impossible to derive from the so and so case support for the proposition that searches and seizures in general are violative of the privilege of protection against self-incrimination. Nor is it possible to import that doctrine with differentiation between legal and illegal searches into the Constitution, because we have nothing in our Constitution corresponding to the Fourth Amendment enabling the courts to import the test of unreasonableness or any analogous criterion for discrimination between legal and illegal searches. And then ultimately, they say that search and seizure is not the same as compelled production. It is therefore clear that there is no basis in Indian law for the assumption that search and seizure of a thing or document is in itself to be treated as compelled production of the same. And then finally, in a very small manner, they deal with the right of privacy because that was one of the arguments that was raised. What they say is this: a power of search and seizure in any system of jurisprudence, an overriding power of the state for the protection of social security, and that power is necessarily regulated by law. When the constitution makers have thought fit not to subject such regulation to constitutional limitations by recognition of a fundamental right to privacy, analogous to the American Fourth Amendment, we have no justification to import it into a totally different fundamental right by some process of constrained construction. So there they say that the right to privacy is not part of the constitution, and the constitution makers in their wisdom had not included it specifically in the constitution, and therefore it is not a fundamental right. So this is the first limb or the first kind of uh, thought process of the Supreme Court on whether the right to privacy is a fundamental right or not. And I would submit that insofar as this eight judge bench, I would argue that this eight judge bench was wrong when it said that it is not a fundamental right. And the reasons will become clear shortly. Then we come to the second limb or the second thought process of the Supreme Court, which happened only a few years later. And here there's a six judge bench in Kharak Singh in 1963, which holds again that the right to privacy is not a fundamental right. But what is important, and I will deal with that, is the dissenting judgment of Justice Subbarao. But anyway, so in this case, as I mentioned, it's a six judge bench of the Supreme Court sitting in a challenge under Article 32 over Chapter 22 of the UP police regulations on the ground that they violate Article 19(1)(d) and Article 21. Now, this case I will call the history sheet case, and it deals with surveillance done by police officers uh, under the UP police regulations. Now, I'm sure we have all heard of the term history sheeter, and history sheeter in it's only an Indian concept where a person who has a long criminal record is referred to as a history sheeter. And here they actually had something known as a history sheet, which on which they put repeated offenders, well-known criminals, and they had Class A and Class B. So the more serious offenses were of theft, burglary, etc., were covered by Class A, and Class B was the professional criminals, etc. So they were all put into a surveillance book, and under the UP police rules, they were surveilled secretly, and there were also domiciliary uh, visits or visits to their house at any time of the day, at any time of the night. They were called to the police station, etc. And so these ultimately the rules themselves, the regulations were challenged before a six-judge bench. Um, so what do they hold in this case? So what was the kind of surveillance, firstly, that was covered? Uh, Frequently, the chowkidar of the village would come and the police constables would enter the house of the person who was on the history sheet, disturb his sleep. They would come and watch his house, not prevent people from entering, but question him and others whenever he left the house. Um, all these kinds of things were the surveillance that was being conducted. And the defense of the police was twofold, or of the state was twofold. Firstly, that the regulations did not constitute an infringement of any of the fundamental rights under Part 3 of the Constitution. And secondly, even if they did constitute an infringement, they were in the interests of public order and therefore they were reasonable restrictions. These were the two limbs of the argument. So the second, so the two arguments, as I mentioned, of the state were as follows. One was that it was not an infringement of Part 3 of the Constitution, and secondly, that it was a reasonable restriction. Now, insofar as the second limb was concerned, what the judges say is that that cannot be an argument in this case because, admittedly, the UP police regulations are not a statute or any kind of a statutory provision, including rules issued under statute, etc. And therefore, they have no statutory basis. And the reasonable restrictions can only be restricted by a statute or regulations, etc., framed under a statute. Whereas in this case, they were simply a procedure established by the police having no statutory basis whatsoever. So that argument was discarded. The only argument that remained was whether these regulations violated the constitution themselves. And on that, they went on to decide. Now, regulation number 236 was the one which came under fire, which they were seeking, the petitioners were seeking to strike down. And the grounds under regulation 236 for surveillance were as follows. They could do surveillance of any of the following by adopting any of the following measures. Firstly, secret picketing of the houses or approaches of the houses of suspects. Secondly, domiciliary visits at night. So they could it literally said that they can visit their houses at night. Then, thirdly, periodical inquiries into the repute, habits, association, income, expenses, and occupation of such accused. Then reporting by constables and chowkidars of movements and absences from home, and the verification of movements and absences by means of inquiry slips. And lastly, the collection and record on a history sheet of all the information bearing on the conduct of the suspect. So this was what could have been surveyed, the surveillance that could have been done. Now, insofar as secret picketing is concerned, what the judges hold is that uh, it is not violative of either Article 19(1)(d) or Article 21 of the Constitution. Article 19(1)(d) speaks about freedom to move throughout the territory of India. And by secretly picketing and watching the houses of the suspects, it means that you're surveilling them from outside. That doesn't prevent you from actually moving about or traversing the territory of India. And so that was not a physical restraint, and it doesn't constitute a impingement on Article 19(1)(d). But they also say that, look, this doesn't mean and simply there's no psychological element involved in I mean the suspect is not being psychologically prevented from leaving, and in any case there is no confinement to the home, and therefore Article 19(1)(d) does not apply. Then, insofar as domiciliary visits at night were concerned, this is very interesting. Again, they say that Article 19(1)(d) prevents someone from moving freely throughout the territory of India. And since someone visiting the house of a suspect doesn't constitute him being prevented from moving freely through the territory of India. It is not, in that sense, an infringement of Article 19(1)(d). This locomotion, they say, is not impeded. You can locomote throughout the territory of India. The psychological inhibition against movement does not impede free movement because it's free. The psychological aspect cannot be looked into only if there's a tangible and physical uh, effect that can be looked into, not the imponderable effect on the mind of a person. So that was the first ground where they said 19(1)(d) doesn't apply. But under Article 21, they say that life and liberty is very wide and it may amount to infringement of the personal liberty, which is read into Article 21 of the Constitution. The personal liberty of a person is being infringed upon when someone makes visits their house at midnight when they haven't been even uh, you know convicted of any offense. So they say that this domiciliary visits at night are unconstitutional and violative of Article 21. Now, where does privacy come in? They also discuss the concept of privacy. And what they say that is then the word personal liberty to be construed as excluding from its purview an invasion on the part of the police of the sanctity of a man's home and an intrusion into his personal security and his right to sleep, which is the normal comfort and dire necessity for a human existence as an animal. And then they deal with the right to privacy, and they say the security of one's privacy against arbitrary intrusion by the police is a basic. This is what has been held by the Supreme Court of the U.S. that it is a basic concept to a free society. So they refer to this judgment of Justice Frankfurter in Wolf versus Colorado, and then ultimately the conclusion is this: it is true that the decision of the US Supreme Court, from which we have made these extracts, had to consider also an impact of violation of the Fourth Amendment. Fourth Amendment reads as such: our Constitution does not in terms confer any like constitutional guarantee, that is, the right to privacy. Nevertheless, these extracts would show that an unauthorized intrusion into a person's home and the disturbance caused to him thereby is, as it were, the violation of a common law right of a man, an ultimate essential of ordered liberty, if not the very concept of civilization. And then their conclusion is this: they strike down Regulation 236B insofar as domiciliary visits constitute a violation of the Constitution. But they hold that the Constitution does not recognize the right to privacy as a fundamental right. And this is the only narrow aspect where they get this judgment wrong. Otherwise, in my view, this judgment is a very progressive judgment. But what does Justice Subbarao in his dissenting judgment say? Justice Subbarao's dissenting judgment is interesting because he comes to the same conclusion. He says that uh, Regulation 236B is ultra vires the Constitution, but he says that privacy is a fundamental right and can be read into the personal liberty of a person under Article 21. Of course, he's in a minority. It's only him versus five other judges. But I think his view is the correct view. So let's see what he actually says. He refers to A.K. Gopalan's case, which is important because that was later struck down. It is true, our constitution does not expressly declare a right to privacy as a fundamental right, but the said right is an essential ingredient of personal liberty. Every democratic country sanctifies domestic life. It is security. It is expected to give him rest, physical happiness, peace of mind, and security. In the last resort, a person's home where he lives with his family is his castle. It is his rampart against encroachments on personal liberty. The pregnant words of famous Justice Frankfurter in Wolf versus Colorado, pointing out the importance of the security of one's privacy, against arbitrary intrusion by the police could have no less application to an Indian home as to an American one. Very important. If physical restraints on a person's movements affect his personal liberty, physical encroachments on his private life would affect it in a larger degree. Indeed, nothing is more deleterious to a man's physical happiness and health than a calculated interference with his privacy. So in 1963, Justice Subbarao had, in his dissenting opinion, made these far reaching observations, and in the years to come, as we will see, they were accepted as the correct law. So, we've talked about the two judgments of the Supreme Court, one a eight-judge uh, judgment and one of a bench strength of six judges, which both say that the right to privacy is not a fundamental right. And this is strange because in succeeding years, other judges of the Supreme Court hold, and these are smaller judges, not smaller benches, not as large as six and eight judges, which hold that the right to privacy is a fundamental right. So the aftermath, after 1963, there's a series of judgments, including Gobind State versus State of MP, Maneka Gandhi, State of Maharashtra was in Madhukar Narayan. This is from 1970 onwards, 1970, 1978, 1991. R. Rajagopal versus State of Tamil Nadu, People's Union for Civil Liberties. All of these are two or three judge benches. Mr. X versus Hospital Z, Sharda versus Dharmapal, etc. They all hold that there is a right to privacy enshrined in the Constitution under Article 21, but it is not an absolute right, and that it can be restricted and curtailed on just and equitable grounds. Uh, and importantly, in Sahara India Real Estate versus SEBI, which is a 2012 judgment, a constitution bench, that is a five-judge bench of the Supreme Court, holds that Justice Subbarao's judgment in Kharak Singh is the correct view of the matter. So this is as things stand in 2012. Now, and they also say that the basis on which Kharak Singh was passed was A.K. Gopalan's case, which was later on set aside by the Supreme Court by a larger bench, and therefore impliedly even the judgment of Kharak Singh ought to have been set aside or was set aside, but it was never stated to be set aside. So this is the position of law till around 2012, 2015. Then an interesting thing happens. We have the Aadhaar, which is promulgated, and there's a challenge to the Aadhaar, a constitutional challenge to the Aadhaar, on the basis that it violates the right to privacy. Now, all of this is happening in 2015, and ultimately, what happens is that a nine-judge bench is constituted. What they say is that, look, in Kharak Singh and in MP Sharma, which are two judgments of very large benches, eight and six respectively, they have held that the right to privacy is not a fundamental right. After that, there have been various judgments of smaller benches which have held that it is a right to a right, it is a fundamental right under the Constitution. But those judgments could not have held that because of the larger bench judgments which say that it's not a fundamental right. So we will constitute first a five-judge bench was constituted to see whether those earlier judgments saying that it is a fundamental right were as per the uh, were valid because it amounted to judicial indiscipline. But thereafter, the question of whether the right to privacy is a fundamental right itself was decided to be argued or decided to be decided finally, and the status of the right to privacy was to be decided by this nine-judge bench. And there we come to Justice K.S. Puttaswamy versus the Union of India. Now, this judgment is a landmark judgment on privacy in India. It is a 637-page judgment and contains six opinions out of the nine judges that sat on the bench. Out of 637 pages, 90 pages is just the head notes, and then the balance 547 pages approximately is the judgment itself. This judgment constitutes a majority, or rather a plurality opinion of Justice Chandrachud, Justice Chief Justice Kehar, Justice Agarwal, and Justice Nazir. But there are also dissenting judgments of five other judges, including not dissenting, I should say rather concurring judgments of five other judges, including Nariman, Kaul, Bobde, and Sapre and Justice Chelameshwar. So five other judges have given their own opinions. Now the operative part of the judgment is as follows. What they say is the reference is disposed of in the following terms. The decision in MP Sharma, that is the eight-judge bench, which holds the right to privacy is not protected by the Constitution, stands overruled. The decision in Kharak Singh, to the extent that it holds that the right to privacy is not protected by the Constitution, stands overruled. The right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 and as part of the freedoms guaranteed by Part 3 of the Constitution. So they don't restrict it only to Article 21. They say that all the freedoms under the Part 3, that is fundamental rights of the Constitution, include the right to privacy. And then they say the decisions subsequent to Kharak Singh, which we just spoke about, which have enunciated the position of law, lay down the correct position of law, and not Kharak Singh itself. So they affirm all those division bench, three-judge benches of the Supreme Court, which has held that the right to privacy is a fundamental right. Now let's look at the judgment itself, because there are several views. This was the operative part which all the judges agree upon. But each, as we've seen, there's six different opinions, and there's six different ways in which they've gone about the judgment. So we can first refer to Justice Chandrachud's judgment because he speaks for himself and three other judges. So in this connection, what he says is that the right to privacy is included in the right to human dignity and autonomy under Article 21. And he rejects the argument that it is the right to privacy is merely something that is for the elitists. He also says that in today's digital economy and the dangers of data mining, etc., there needs to be a data protection law, which is very important to protect not only privacy vis-a-vis the government, but privacy vis-a-vis non-state actors as well. So this is what they say, and they encourage the four judges, Chandrachud and three others, encourage the government to come out with a data protection law. Then Justice Chelameshwar's judgment is quite interesting. What he says is that there are three facets to the right to privacy. Uh, the right to repose, that is freedom from unwanted stimuli. I can repose myself, I can withdraw myself, and I need not get, I have the right to not be stimulated unnecessarily. Then sanctuary, the right to protection from intrusive observation. So that's the second limb of the right to privacy, which is sanctuary, I have the right to be protected from intrusive observation. And the third limb is the right to intimate decision, that is, the right of autonomy and to make personal life decisions. And this is the most important, according to me, because ultimately, autonomy, as human beings, we have to have the right to be autonomous and live a life with dignity. And this has also been construed in several other judgments. So, this is the test of whether the right to privacy exists or not, according to Justice Chelameshwar. And I think this is a correct approach. And then, of course, uh, Justice Bobde also has his own opinion. similar to that of Justice Chandrachud. Justice Kaul identifies two aspects of the right to privacy. He says against the state actors, as I mentioned, and the non-state actors. In respect of the state actors, he identifies the concerns of surveillance and profiling. The judgment that we read on the history sheeters, that is Kharak Singh, he addressed that judgment as well. And he says that you have to make sure that surveillance does not violate the right to privacy. And secondly, insofar as non-state actors is concerned, he echoes the judgment of Justice Chandrachud, where he says that there must be a data protection law in place to protect our private digital data. Now, what is the majority opinion on the test of infringement? Firstly, they agree with the concept that the right to privacy is not an absolute right. They say it can be restricted by procedure established by law, which is the general test of how the right to life and liberty can be restricted. It can be restricted by procedure established by law, but the procedure established by law has to be just, fair, and reasonable. If it is not so, then it cannot be said that the uh, a personal liberty has been correctly restricted. So this is the proportionality test, which is established by the judgment, and this is also the judgment written by Justice Chela Meshwar gives a good overview by highlighting the question of reasonableness, etc. Justice Chelameshwar's judgment also includes a fourth test. It includes a fourth test to privacy claims, where he says that, and this is the most important test, that an infringement of privacy can only be justified in case of compelling state interest. This is in case of state actors. It can be justified only in case of compelling state interest and not otherwise. So this is the judgment of the Supreme Court in the Justice K.S. Puttaswamy versus Union of India 2017 case, 9-judge bench. Now, we've spoken about uh, the three major judgments on privacy, but thereafter, after Puttaswamy case, there has been an aftermath, and the aftermath of the recognition of privacy has been very positive and very optimistic for normal citizens like you and me. And why is that? Because the test of privacy has been applied in a number of decisions of the Supreme Court to uphold other rights of ours. For example, the judgment of Puttaswamy came out in 2017. In 2018, a three-judge bench of the Supreme Court in the Shafin Jahan case held that intimacies of marriage lie within the core zone of privacy of an individual and are inviolable, and one has an absolute right to choose a partner who you want to marry, etc. So what they say is interesting. In the judgment, they say the choice of partner, whether within or outside marriage, lies within the exclusive domain of each individual. Intimacies of marriage lie within the core zone of privacy, which is inviolable. The absolute right of an individual to choose a life partner is not in the least affected by matters of faith. The Constitution guarantees to each individual the right to freely practice, profess, and propagate a religion. Choices of faith and belief, as indeed choices in matters of marriage, lie within an area where individual autonomy is supreme. So, the parents, for example, in this case, could not have told their daughter who to marry, who and who not to marry. This is a matter which is of personal autonomy and lies within the domain of the individual themselves. And then they also rely on the Puttaswamy judgment to say that a 9-judge bench of this court has held that matters close to one's life is an inviolable aspect of human personality. And right to privacy includes the right of autonomy. So therefore, they use the right to privacy in the case of marriage privacy, firstly. Then secondly, this right to privacy, the doctrine has been used in the case of sexual privacy as well, in the Navtej Singh Johar case, which is a five-judge decision of the Supreme Court. And the judgment basically decriminalizes consensual sexual relations between persons of the same sex and decriminalizes or strikes down Section 377 of the IPC insofar as it applies to same sex consenting adults. So, here too, they apply the test of the right to privacy, and they say that look, the right to life and personal liberty under Article 21 includes the right to dignity and privacy, and most importantly, sexual privacy. And the judgment of Indu Malhotra, I think, really summarizes this aspect because there are several judgments again. There are three or four judgments which are concurring. But the Justice Indu Malhotra has really summarized the concept of the right to privacy nicely when she says that the right to privacy is broad-based and pervasive under our constitutional scheme and encompasses decisional autonomy to cover intimate personal decisions and preserves the sanctity of the private sphere of an individual. The right to privacy is not simply the right to be let alone and has traveled far beyond that initial concept. It now incorporates the ideas of spatial privacy, decisional privacy, or privacy of choice, that is, autonomy. It extends to the right to make fundamental personal choices, including those related to intimate sexual conduct without unwarranted state interference. The state cannot decide that who am I supposed to marry, who I'm entitled to have sexual relations with. These are all within the personal autonomy of an individual. So these are two concepts. Now it has also been applied in 2019 in Joseph Shine versus Union of India, where Section 497 of the IPC was struck down. Section 497 talks about adultery and provides that where any man has sexual relations with a wife of any other man, then he shall be imprisoned for a term up to 5 years. So what the judges held was that firstly, on the basis of the Puttaswamy judgment, I cannot be prevented from having sexual relations with anyone that I want. Of course, this may be ground for adultery, may be ground for divorce, but that doesn't mean that it should be a criminal activity. The state can't regulate. They also say that that section 497 of the IPC is patriarchal and violates Article 14 because women are treated, or wives of men are treated as kind of objects, and it's only a man who can be uh, guilty of adultery, not a woman. So these were all situations where it amounts to a violation of Article 14, arbitrariness. So ultimately, the judges have applied this concept of privacy even in decriminalizing adultery. We've spoken about marriage privacy, sexual privacy, decriminalizing adultery. These are all cases of personal dignity and autonomy in which the right to privacy has been employed by the Supreme Court and repeatedly in years succeeding 2017, which was the year in which the Puttaswamy judgment came. Now, in another case, that is the Aadhaar card case, which is a 2019 judgment also titled K.S. Puttaswamy versus Union of India. The judges hold something different. What they say is that yes, the right to privacy is there, but the Aadhaar regime, by and large, does not violate the uh, doctrine of proportionality. In fact, it meets the test of proportionality, and therefore it's not violative of the right to privacy. But again, they recognize that a nine-judge bench in Puttaswamy number one has held that the right to privacy is an inviolable right to all citizens and all persons under Article 21 and under Part 3 of the Constitution. But they say in this case, this does not amount to a violation of the right to privacy because of the doctrine of or the test of proportionality that we spoke about earlier. And then lastly, as we mentioned in 2017 judgment, there were talks about the government coming out with a data protection law, and the judges being active in this encouraged the government to come out and promulgate that law. So a Sri Krishna committee was appointed uh, to suggest a prospective law. Pursuant to that, a personal data protection bill was introduced. It was amended, then it was withdrawn, and then finally, a digital personal data protection bill came out in 2023, and it was passed and became an act also in 2023. So that is the outcome of the judgment of the nine-judge bench, and we are to be very thankful for that judgment because it has protected our civil liberties and has granted us additional freedoms uh, merely because of those nine judges who interpreted the Constitution and made sure that the right to privacy was recognized explicitly as a fundamental right under Part 3 of the Constitution. So I am pretty much done with my presentation. I'm happy to field any questions that you may have because I find these judgments and you know uh, these debates in the Supreme Court on constitutional law really the most important to each and every one of us on an everyday basis. And the aftermath of these judgments can be immense. So, really, uh, I find this topic interesting. I'm happy to field any questions that you may have.
Thank you for such a wonderful session. Participants, in case y'all have any queries, either you can post the same on the chat box or you can use the raise hand function. We will unmute you. So, Anirudh, there's a question. Sir, can you please reiterate what is doctrine of proportionality and in what cases can it be applied?
So, the doctrine of proportionality, as I mentioned before, is where uh, anything which infringes on the uh, right of privacy, which is an inviolable right, has to be something which is by procedure established by law under Article 21 and also has to be uh, fair, just, and reasonable, and in compelling state interest. That is the test that has been established by the Puttaswamy judgment and in earlier judgments as well, including the People's Union for Civil Liberties case, where the doctrine of proportionality means that you cannot restrict a fundamental right of life and liberty, which is what the right to privacy comes under, except by procedure established by law, that is uh, mostly a statute, and that has to be just, fair, and reasonable, and in compelling state interest.
Okay. The next question, in legal parlance, do privacy and security mean the same?
Privacy and security are two different aspects. Security usually means uh, safety, if you use it in that sense, safety, personal safety. But privacy means the right, as we mentioned, there's in the Puttaswamy judgment itself, they have said that the right to repose, sanctuary, and intimate decision, these are the three aspects of the right to privacy, which means that the right to repose is freedom from stimuli. Suppose I don't want to be disturbed by someone. I have that right as a person who's living in India to be to not be disturbed. For example, the surveillance in the middle of the night would uh, really amount to a disturbance of my right to privacy in this sense. Then the right to sanctuary, which means protection from intrusive observation. Suppose I don't want someone peering into my house or looking into my house with binoculars. This is again
The next question is, Is right to be forgotten articulated in any Indian law?
Right to be forgotten. Well, it's not contained in these judgments, but we can discuss that. That's a different topic altogether. We can discuss it after this call offline if necessary.
How does right to privacy apply to the digital media?
So nowadays, what is happening is that we are all on social media all the time, and now the data privacy law, which has been promulgated, which is the Digital Personal Data Protection Act, what it essentially does, or it's aimed at doing, is ensuring that the information that is available for you online, the personal information, such as, for example, your social media accounts or uh, your preferences in what to shop for, or any information linked to you, which is personal to you and is digital, is protected or in some ways regulated. Because many times what happens is these companies, for example, large companies who have access to this information, they have access to what your preferences are, what your shopping tastes are like, what what colors you like, everything they will know. And then they sell this information. They mine this information firstly, and then they sell it to the highest buyer. And so this is a part of your right to privacy, that you don't want people to know what your preferences are, etc. And you want it to remain personal to you. So in that sense, this is the kind of digital information which is sought to be protected by the act which has come out.
Okay. The next question is, recently there was a judgment by the Supreme Court on admissibility of call recordings. Supreme Court, um, wait a second. Yeah. Supreme Court said there has to be a balance between privacy and liberty, and hence the call recording by the husband was not admitted as it was violation of right to privacy of the wife. What is your view on this, and can call recordings be admissible as evidence?
So, as far as I know, and the Supreme Court has held in a number of cases, that unless a person knows that they are being recorded, or they're told explicitly that they are being recorded, and with that knowledge, they go ahead with the call. Unless that is the case, those recordings are not admissible in evidence. And as you mentioned, perhaps what the judgment that you are referring to has also indicated is that these call recordings will be a part of your private conversations, and therefore, unless you have given permission to the person who's recording to record and use the information, it cannot be admissible in evidence. So that is also a part of this repose, sanctuary, and intimate decision. In fact, it is, uh, I would say, it amounts to sanctuary. You don't want someone recording you unless you have given them permission to do so.
Okay, one more question on the chat. Are there any courses on privacy related law that you know of?
I don't know of any formal courses, but I'm sure there are lectures and talks like this which happen on and off. And really, the way to understand this law is to do a little bit of reading on. If you read the Supreme Court judgment, of course, it's 600 plus pages, but it will give you an overview of what the right has been that has been recognized. And then, secondly, also study the act, because that's only an aspect. It's your personal digital data which is covered by the act. But I'm sure there will be some commentaries or some books on that act. But as of now, I'm not aware of any formal courses on privacy law.
This is a very generic question. What? No, sorry. Can you shed some light on the new DPDP rules 2025?
So, I mean, again, it's a very, like you said, it's a very general question. But in what sense? Look, the rules are under the act and cannot go beyond what is stated in the act. But if you have any specific questions on the rules or something which you need clarity with, I'm happy to explain. No, I said that if there's any specific question that they have with respect to the rules, I'm happy to answer it. But like you mentioned, it's a very
Yeah, very
general
generous. Yeah.
question.
So, participant or whoever posed that question, if you have anything specific in mind, please you can ask that. Sorry. This is the last question. On whom
Sure.
does the burden of proof lie in right to privacy matters?
Burden of proof, what do you mean by burden of proof? See, usually right to privacy is not a suit. A suit is where you have to prove something and the burden of proof lies on someone. But right to privacy matter will usually be where the state has as in the case of the search and seizure, or in the case of uh, the what do you call it, the history sheet case. In those cases, the state had infringed upon the right to privacy. So therefore, those rules, those regulations of the UP police were challenged, or the right to search and seizure was challenged, and that would be by way of a writ petition. So it wouldn't be a suit where you have to prove something, because it's not really a disputed fact. So there's no burden of proof as such. It's only a question of law which has to be argued of whether something is legal or not.
Okay. Sorry, Anirudh, one more question. What are the penalties against violation of right to privacy in India?
I mean, the DPDP Act has some penalties. I'm not aware of it offhand, but you can just look up the act. The act itself will give you what are the penalties for, breach of the provisions of the act.
Okay, Anirudh. So I think we are done with the queries. Can we conclude the session?
Yes. Thank you so much.
Thank you so much, Anirudh, for such an enlightening webinar. It was really helpful to the participants, I'm pretty sure. So, thank you.
Thank you so much. Thank you, Malvika. Thank you for having me.